Hi, I'm Aslam Moolla and I'm a CCMA labor lawyer. In today's video, I'm going to take you through disciplinary hearings and how to prepare for them step by step. I get quite a few queries from clients saying, Aslam, I've just received my disciplinary hearing notice. It's in 48 hours time. I don't know what to do. How do I go about preparing for it? Where do I get my evidence? What do I say? What process is involved? And naturally, it can be quite overwhelming, especially if it's the first time that you're going through a disciplinary hearing. So essentially, in today's video, we're going to cover how to prepare for a disciplinary hearing step by step, and to make sure that we understand the process so that you're feeling much more confident. The first step is to understand what the charges are against you. You can identify the charges by the notice of disciplinary hearing. It will list the different charges that are against you. So step one is to identify these charges and indicate whether you plan on pleading either guilty or not guilty. Of course, this is dependent on the facts of your situation and what evidence you have. If you believe you're innocent, you are naturally going to write not guilty. If you believe that you are guilty and that you want a lesser sanction, then you're going to write guilty. So step one is to write down whether you plan on pleading guilty or not guilty next to each charge listed against you. Step two is to indicate the reasons why you plead not guilty. So this is assuming, of course, that you plan on pleading not guilty. You have to indicate the reason why. So for example, let's just use an example that John has been charged with theft of money from the workplace. He plans on pleading not guilty. That was step one. Step two, he is now providing the reason why he's saying he's not guilty. And the reason is he was not at work on the day that the day that they are accusing him of stealing the money. Let's just say that he wasn't at work, in that he had a sick note and he was at the doctor. So it was impossible for him to steal the money. So step one, identify whether you plan on pleading guilty or not guilty. Step two is the reason why you are pleading guilty or not guilty. Step three is to give the evidence as to why you are not guilty. What evidence do you plan on using to prove your innocence? So in this particular example with John, who was accused of stealing money from the workplace, he identified he is not guilty. Step one. Step two, he provided the reason, which is he was away from work on the day that they've accused him. And step three, the evidence is the doctor's sick note, which was on the same day that they're accusing him. So he can't be at work. That essentially is the process to identify the charges and come up with your evidence. Now, the challenge that we have often from clients is that they do not have access to evidence to prove that they are innocent. Oftentimes, the evidence is on laptops or company emails, or it's at the workplace. And my advice is you definitely need to get access to that evidence. If you do not have that evidence, it's going to be very difficult for you to prove your innocence. So as soon as you get that notice of disciplinary hearing, on the same day, you must write to the employer and request the information that you need to prove your innocence. Whether that's an email, whether that's witnesses, documents, put it down in writing and request it from the employer. It's very important, and make sure you have a copy of that so you can produce it later on, either at the CCMA or the labor court, when it comes to proving your case. That you needed this information, you've requested it, and the employer has refused to give it to you. Now that we've identified each one of the charges, we've indicated whether we're guilty or not, the reasoning why we're innocent, and the evidence, the next step is, of course, to attend the disciplinary hearing. You must attend the hearing. If you don't attend the hearing, there is a possibility that it will happen in your absence and you will be found guilty by default. Naturally, you don't want that to happen. So make every effort to attend the disciplinary hearing. On the day of the hearing, you are going to be feeling anxious, nervous, overwhelmed. Remember to keep yourself calm. Remember to focus on the facts. You are there to present your case in the best light possible. And if you're stressed, you can't do that. So after you've accumulated your reasons and your evidence, you must attend the hearing. At the hearing, on the day of the hearing, it's very important that you give a good opening statement. What is a good opening statement? A good opening statement is a summary of your case. It involves things like how long you've been working at the company, the reason for your innocence, and what evidence you intend leading for your innocence. So let me give you an example of an opening statement. You can say, "Hello Chairperson, my name is John. I'm from Durban. I've been working at this company now for 3.5 years in the position of manager. I've been falsely accused by these charges. The reason why I'm innocent is because on the day that they're accusing me of stealing the money, I was not even at work. I have evidence from a doctor's note to prove that, and I believe that these charges should be removed against me because of my innocence. If I am found guilty, I am prepared to take this matter to the CCMA to enforce my labor law rights." That's a good example of an opening statement. The next step in the process is to listen to the employer's version of the case. The employer is going to start. After opening statements, the employer starts. Listen carefully to the witnesses and what documents they are using. Make sure you keep written notes so that you can challenge each point that's raised against you. It's very important. You must put your version to the witness or the document. You cannot let the employer just say something without challenging it. After the employer is done, it's now your turn to lead evidence. You're going to lead your witnesses, your documents, WhatsApps, emails, anything you have to prove your innocence. It is very important that you put your best foot forward. Make sure you lead your case with passion and you focus on the facts. After you're done, then usually there'll be closing arguments where you're going to summarize your case and the employer will summarize its case, and then a ruling will be made by the chairperson. The ruling, after you get the ruling, if you're not happy, you must refer your case to the CCMA. For example, if you have been dismissed, you only have 30 days to refer your case to the CCMA. Make sure you get it done as quickly as possible. In terms of how to refer a case, we've done a separate video for that. You can check that out. But in essence, you go to the CCMA website and fill in a 711 form where you refer your case to the CCMA. So in today's video, just to recap, what we've covered is the following. Once you get the charges against you, identify whether you're guilty or not guilty. Identify the reasons why you're not guilty. Identify the evidence that you plan on using. Then you must attend the disciplinary hearing. Give a good opening statement. Listen to what evidence is being led against you. Challenge that evidence and then lead your own evidence. This video is meant as a guide. Of course, if you need particular help in your situation, you're more than welcome to book an appointment by clicking the link below, and I'll speak to you soon. If you have a case, good luck.